Hi everyone. Under section 5, we have already discussed about the conditions of a valid Hindu marriage. Okay. So, under that, we have discussed about the five conditions which are really, really important to make a marriage valid as per the nature. Okay. So, coming to the next part, um, we have understood about the point of your restitution of the conjugal rights, and we have also understood about the judicial separation. Okay, so under the restitution of the conjugal rights, we have understood that when one party or one spouse is living separated from another party or another spouse without giving any proper explanation to another spouse, without giving any valid reason, or without explaining the proper conditions of the marriage, without explaining what is the reason of the separation, then the another party can file the restitution of the conjugal rights against the another party. Okay. So coming to the point of the judicial separation, we have understood that upon the happening and non-happening of certain incidents, or upon the certain conditions, the court can issue a judicial separation as per se. So, what do you understand by the judicial separation? Before granting a divorce, if anything has been granted, that is called the judicial separation. That means if me and my partner is going to the court of law and applying for the divorce petition, or filing our divorce petition, in that case, before granting us the divorce, if anything, the court will grant us, that is the judicial separation. That means if the court is satisfied with certain terms and conditions of the marriage, if the court is satisfied that yes, both of the parties are not okay and not eligible to stay with each other anymore, they are not understanding each other, like there is certain issues which cannot be compromised, which cannot be sorted out, and both of the parties do not want to stay with each other, then in that condition the court may grant further judicial separation. The court may order that yes, at this condition the both of the parties should stay separate from each other. Okay. So uh, coming to the part of the voidable marriage or void marriage, we have understood that what are the conditions of a void marriage. And under section 13 of the Indian Hindu Marriage Act, we have also understood about the conditions of the divorce under clause 1 and clause 2 and clause 3 of the Hindu Marriage Act. So when we have discussed about the clause 1 of section 13 of the Hindu Marriage Act, this has exactly told about the concept of the divorce. Okay. So when we are talking about the concept of the divorce, then it is clearly said that any marriage solemnized before the after the commencement of this act be dissolved by a decree of divorce on the ground of the other party. Okay. And when we are talking about the conditions of the divorce, or the successful conditions when the divorce is being granted or the divorce is being completed, there are certain rules and regulations, there are certain terms and conditions which need to be completed before the approval of the divorce. So what are those conditions? Under the clause 1, we have understood about the few conditions. First, we have understood under I that when the partner or the another spouse has the voluntary sexual intercourse or sexual intercourse condition with the another, except the spouse, with another person, like that is called the extramarital affairs, we can say in simply, when the person, any of the spouse, is having extramarital affairs with another person except his or her own spouse, अपने पति या पत्नी को छोड़ के दूसरे किसी के साथ शारीरिक संबंध रखना या कोई भी ऐसा एक्टिविटी करना which will indicate extramarital affairs with other person except the husband or wife. That is the most important ground for the divorce or the judicial separation. The second ground we have understood, after the solemnization of the marriage, treated the petitioner with the cruelty. That the first person treated the another person with cruelty, with anger, with frustration. That is called torturing. Just like we have already discussed about the physical cruelty and the mental cruelty. And I have already made you understood that when we are talking about the physical cruelty, it's about hurting someone, it's about hitting someone, right? But when we are talking about the mental cruelty, that can happen in different modes. Just like I am trying to abuse you by using slangs, by using very, very bad languages. I'm mentally harassing you. I am making you depressed. So these kind of the circumstances or these kind of conditions are comes under cruelty or cruelty. Okay. The third condition, has deserted the petitioner for a continuous period not less than 2 years immediately preceding the presentation of the petition. Okay, what does it mean? Has deserted the petitioner for a continuous period not less than 2 years immediately preceding the presentation of the petitioner. That means both of the partners, the husband and wife, from the date of the petitioner, from the last 2 years, they have not stayed together with each other. That means both of the parents, they are living separately from each other from the last 2 years. Okay. The next point, has ceased to be Hindu by conversion to another religion. When one of the partner is getting converted into another religion, that means, for example, if I am a Hindu, I have converted to Christian or Muslim. At that case, my wife can ask for the divorce upon that particular ground of the changing the religion. That means, if any of the spouse who is particularly belongs to any particular religion and following any kind of specific religion, and due to certain conditions the partner is changing its own religion or changing its own habits, own belief, own culture, own tradition. So in that case, if we put a condition like, yes, there is the circumstances when the partner can take the divorce upon this specific condition, then this kind of agreement or this kind of condition is totally valid in nature. Okay. Next point, has ceased to be Hindu by conversion of another religion. And then number last, it speaks about incurably of unsound mind. Okay. That means when the partner is of the unsoundness of the mind, when the partner is not at a good mental state where he or she can carry or pursue his activities, or he or she is eligible to give his consent for the marriage happily. That means the mental condition of any of the spouse is not stable, and due to the unstable mental condition, the spouse is unable to balance the situation, or it is very, very difficult for another partner to adjust with the husband or wife due to the mental instability of the partner. And that is the major condition when the another party or the another spouse can ask for the divorce upon this specific ground. Okay, clear? Then the next condition it speaks about, uh yeah, the explanation. Leave it. It has been just described the psychopathic disorder, the mental distress, the mental condition, all these things it has been talked about. Uh, Either party to a marriage, whether solemnized before or after the commencement of this act, may also present a petition for dissolution of marriage by a decree of divorce on the ground that there has been no resumption of cohabitation between the parties to the marriage for a period of 1 year or upwards after the passing of a decree for judicial separation in a proceeding to which they were parties. Okay, that means when the decree of the judicial separation has been passed. Okay. And after the passing of the decree of the judicial separation, okay, yeah, that means both of the parties, the husband and wife, they have been issued the conditions of the judicial separation upon certain ground. That means, मान लीजिए I am having certain kind of the affairs with another person, that is the extramarital affairs you can say. So upon that ground, me and my husband got departed. Okay. Court has granted us the condition for the judicial separation. एंड एक साल से हम एक दूसरे से अलग रह रहे हैं, क्यों? ड्यू टू द ऑर्डर ऑफ द कोर्ट एंड ड्यू टू द ऑर्डर ऑफ द जुडिशियल सेपरेशन. एक दूसरे से हम लास्ट एक साल से अलग रह रहे हैं एंड द कंडीशन इज, एक साल हो गया फिर भी हम एक दूसरे के साथ रहना नहीं चाहते हैं. And upon this condition, if we ask for the divorce to the court cannot deny, and it is the duty of the court to grant divorce upon this condition. जहाँ पे there is the issuance of the judicial separation by the court due to any kind of the circumstances, and it has been seen that after granting the judicial separation, it has been crossed 1 year, but neither of the parties are staying together or neither of the parties want to stay together. In that case, that is the strong ground for the divorce. That may lead to divorce because it is proved that एक साल हो गया जुडिशियल सेपरेशन का ग्रांट करते हुए, जहाँ पे कोर्ट ने किसी ग्राउंड को परख के कोर्ट को लगा कि नहीं अभी एक दूसरे के साथ उन लोगों ने साथ नहीं रह पाएंगे, एंड दैट इज वाई कोर्ट हैज ग्रांटेड अस द जुडिशियल सेपरेशन. जुडिशियल सेपरेशन ग्रांट होने के बाद हम एक दूसरे से अलग रह रहे हैं एंड एक साल चला भी गया, बट अभी भी हम एक दूसरे के साथ रहना नहीं चाहते, एंड दैट इज द स्ट्रॉन्ग ग्राउंड फॉर द डिवोर्स. ऑब्वियसली, क्योंकि यहाँ पे अगर एक दूसरे से अलग हम रह ही रहे हैं तो फिर साथ रहना ही क्यों है, राइट? दैट इज द स्ट्रॉन्ग ग्राउंड ऑफ द डिवोर्स कि यहाँ पे तो एक दूसरे से डिवोर्स हो ही जाना चाहिए. समझ में आ रहा है? So here it has been told that there is no resumption of cohabitation between the parties of the marriage for a period not less than period more than 1 year. And there is one more thing. For example, parties are filed for the petition of the judicial separation. Judicial separation मिल भी गया, उन लोगों ने एक दूसरे से अलग रह रहे हैं, बट मान लीजिए they have made up their mind and they started living together again. एक दूसरे के साथ फिर से रहना शुरू कर दी. And upon that condition, if you ask me, is that particular ground for the divorce? The answer is no. Because यहाँ पे even though the parties they have granted the judicial separation, even after the granting of the judicial separation, they started living together again. वो फिर से एक दूसरे के साथ रहने लग गए हैं. In between the duration of the 1 year of the judicial separation, their mind to get divorced or their mind to get separated from each other has already been changed. And that is why in this condition the divorce cannot be granted. But what if उन लोगों ने जुडिशियल सेपरेशन के बाद, जुडिशियल सेपरेशन का ऑर्डर के बाद एक साल से एक दूसरे के साथ नहीं रह रहे हैं, एंड इन दैट कंडीशन दो कोर्ट कैन ग्रांट देम द डिवोर्स, एंड दिस कैन बी ए स्ट्रॉन्ग ग्राउंड ऑफ द ग्रांटिंग ऑफ द डिवोर्स. क्लियर? Then the next condition, that there has been no restitution of the conjugal rights between the parties to the marriage for a period of 1 year or upwards after the passing of the decree of the restitution of the conjugal rights in a proceeding to which they were parties. Okay. So what does it speak? That there has been no restitution of the conjugal rights between the parties to the marriage for a period of 1 year or more. Okay, that means, for example, one of the spouse has been filed the restitution of the conjugal rights, and हमने आप लोगों को समझाया था. What do you understand by the restitution of the conjugal rights? Conjugal rights means the right to stay with each other. Conjugal rights means the right to live with each other, living together, living conjugately, right to be conjugated, right to be stay with each other. Okay, so when there is the restitution of the conjugal rights, that means that right is getting violated. We have already understood when one partner has left another partner without any proper information. जहां पे आपका एक स्पाउस आपको कुछ भी बिना बताए घर से चला जाए, आपके साथ नहीं रह रहा है, आप उसको पूछ पूछ के थक गए हैं कि क्या वजह है, बता दो आप मुझसे दूर क्यों रह रहे हो, बट फिर भी वो बताना नहीं चाहता है, एंड इट हैज बीन टर्न्ड 1 year और मोर, जब से वो आपसे दूर रह रहा है. देन आपने क्या किया, आपने कोर्ट को गया, यू हैव फाइल्ड ए पिटिशन ऑफ द रेस्ट्रिक्शन ऑफ द कंजुगल राइट्स. आपने कोर्ट को बोला कि दिस इज माय पार्टनर एंड आई वांट माय पार्टनर बैक, आप मुझे मदद करो, मुझे मेरे पार्टनर से बात करवा दो, उसको बुलाओ, मेरे को जानना है कि वो मेरे साथ क्यों नहीं रहना चाहते, व्हाट इज द प्रॉब्लम ओवर हियर. तभी कोर्ट क्या करता है, इशूज द नोटिस टू द अनदर पार्टनर. कोर्ट क्या करता है, दूसरे पार्टनर को नोटिस भेजता है, उनको पूछता है कि व्हाट इज द रीजन फॉर व्हिच यू वांट टू लीव योर वाइफ और यू वांट टू लीव योर हस्बैंड. आप अपने पति के साथ या पत्नी के साथ क्यों रहना नहीं चाहते हैं. एंड आफ्टर लिसनिंग टू दिस क्वेश्चन, if the another spouse or another partner gives the appropriate answer, अगर उसने जो भी आंसर देता है कोर्ट को वो चीज सही लगता है, फॉर एग्जाम्पल उसने बताया कि मेरा जो दूसरा पार्टनर है उन्होंने अपना रिलीजन बदल लिया, उन्होंने हिंदू से मुस्लिम रिलीजन को ले लिया, तो मैं उसके साथ रहना नहीं चाहती. दूसरा कंडीशन मान लो, फॉर एग्जाम्पल the first partner is staying separately from the another partner, and when he or she has been asked कि वो ऐसा क्यों किया, then the husband is saying कि the wife is going through a very bad mental disorder, तो वाइफ के साथ रहना इम्पॉसिबल है, एंड आई वांट टू डू द ट्रीटमेंट ऑफ द वाइफ इन द मेंटल हॉस्पिटल, उसका इलाज भी चल रहा है, एंड आई एम अनेबल टू स्टे विथ माई वाइफ बिकॉज देर इज द डेंजर टू माई लाइफ. वो अपने पागलपन से कभी भी कुछ भी कर देती है, सो आई एम स्केयर्ड ऑफ माई वाइफ. सो हियर इन दिस सिचुएशन you has been or you have been allowed to take to file, you have been allowed to continue this restitution. That means here the court can allow you the judicial separation. ठीक है, आप अपने स्पाउस के साथ रहना नहीं चाहते हो तो मत रहो, we respect that and we are allowing that. But there should be the sufficient and strong ground near the another partner regarding this restitution of the conjugal rights. Okay, so when we are coming about the restitution or restoring of this conjugal rights, after passing the decree of the restitution of the conjugal rights, if there is the crossing of 1 year, still कोई भी पार्टनर एक दूसरे के साथ रहना नहीं चाहता है. मान जाओ देयर इज द डिस्टर्बेंसेस बिटवीन द हस्बैंड एंड वाइफ, द वाइफ हैज फाइल्ड द restitution ऑफ द conjugal राइट्स. सो कोर्ट ने क्या किया, हस्बैंड को एक नोटिस भेज दिया जहां पे ये चीज लिखा हुआ था कि yes, here the husband is staying away from the wife, which is actually violating the right of the wife to stay together with the husband, so the wife has to come back. Okay, then what happens, the wife comes back. वाइफ आके कोर्ट को ये बोलता है कि नहीं, मैं अपने पति के साथ रहना नहीं चाहती हूँ बिकॉज उनका दिमागी हालत ठीक नहीं है, वो बहुत गुस्सा करते हैं, वो मुझे क्रूएल्टी से ट्रीट करते हैं, वो मुझे मारपीट करते हैं. कोर्ट ने भी सारा सबूत देख के ये चीज में पहुंचा कि एक्चुअली द हस्बैंड इज सफरिंग फ्रॉम द मेंटल डिसऑर्डर व्हिच इज नॉट सेफ फॉर द वाइफ. वो वाइफ के लिए हानिकारक है, जो कि वाइफ को आगे जाके नुकसान पहुंचा सकता है. सो द कोर्ट अप्रूव्ड द रेस्टिट्यूशन ऑफ द कंजुगल राइट्स। कोर्ट ने बोला ठीक है, अगर आप अपने पति या पत्नी से अलग रह रहे हो, दैट इज ए गुड थिंग, कोई बात नहीं, हम आपको जबरदस्ती नहीं करेंगे कि आप अपने पति के पत्नी के साथ आके वापस रहो। ओके, बट अगर मान लीजिए कोर्ट ने उनको बोला कि नहीं, उनका मेंटल डिसऑर्डर, आफ्टर ऑब्जर्विंग सर्टन कंडीशंस एंड एवरीथिंग वी हैव टॉक टू द डॉक्टर, डॉक्टर ने बोल रहे हैं कि आपका पति का मेंटली हालत जो है ना, दैट इज नॉट टू बैड, ही इज नॉट गोइंग टू हार्म यू, आप आइए उनके साथ रहना शुरू कीजिए, यू शुड स्टे विथ योर हस्बैंड एंड ही इज नॉट गोइंग टू हार्म यू एनीवे। जब कोर्ट को डॉक्टर से ये एश्योरेंस मिलता है कि वाइफ का हस्बैंड के साथ रहने के बाद उसको कोई तकलीफ नहीं होगी, देन द कोर्ट सजेस्ट द वाइफ टू स्टे टुगेदर विद द हस्बैंड, है ना। बट एक्चुअली what happens that even after getting the notice of the restriction of the conjugal rights, that उसी को अपने पति के साथ ही रहना है, then also the wife is not coming, got it, the wife is not ready to live with the husband. So यहाँ पे क्या बोला गया, that one has been no restitution of the conjugal right as between the parties for a period of 1 year after the passing of the condition rights. That means restitution of the conjugal rights पास होने से क्या होता है, अनदर पार्टी को कोर्ट, द पार्टी हु हैज लेफ्ट द स्पाउस, लेफ्ट देयर फर्स्ट पार्टी और अनदर स्पाउस, उसको ऑर्डर दिया जाता है कि आप अपना पति के पत्नी के साथ आके वापस साथ में रहो। इवन आफ्टर गेटिंग दिस ऑर्डर, मान लो द अनदर पार्टी इज नॉट एग्रीइंग टू स्टे विद द पार्टनर और स्पाउस, एंड इवन दैट अनदर स्पाउस इज नॉट कमिंग बैक, and in that case what is going to happen, in that case it is very clear that this is a strong ground for the divorce, because अगर एक दूसरे के साथ रहना ही नहीं चाहते, इवन आफ्टर द ऑर्डर ऑफ द रेस्टिट्यूशन ऑफ द कंजुगल राइट्स, एक दूसरे के साथ रहना नहीं चाह रहे हैं, दैट मीन्स दिस इज ए स्ट्रॉन्ग ग्राउंड ऑफ द डिवोर्स, एंड अपॉन दिस ग्राउंड बोथ ऑफ देम कैन गेट डाइवोर्स्ड। क्लियर? Next point, a wife may also be present for a petition of dissolution of her marriage by decree of divorce on the ground. Okay, what does it speak? In the case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, or any other wife or any husband married such before commencement was alive at the time of solemnization. Okay, so यहाँ पे क्या बोला जाता है, a wife may also present a petition for dissolution of her marriage on the ground that the husband has married again. Okay, and in between, the husband has married again before the commencement of any other wife of the husband, and the wife is alive at the time of the solemnization of the marriage. Okay, तो यहाँ पे हमने 1A के अंडर जो दो कंडीशन डिस्कस किए, व्हाट डज इट स्पीक अबाउट। पहला कंडीशन तो आपको ये बारे में बताया कि अगर आपका जुडिशियल सेपरेशन ग्रांट हो चुका है एंड जुडिशियल सेपरेशन के बाद भी आप लोगों ने 1 साल तक एक दूसरे के साथ नहीं रहना चाहते हो, एक दूसरे से अलग रह रहे हो, देन द कोर्ट इज गोइंग टू ग्रांट यू द डिग्री ऑफ द डिवोर्स ऑन द अर्लीस्ट मैटर। दूसरा चीज क्या बोला, when the court has granted the restitution of the conjugal rights, कोर्ट ने क्या किया, रेस्टिट्यूशन ऑफ द कंजुगल राइट्स ग्रांट कर दिया, कोर्ट ने ऑर्डर दे दिया था कि आपको पति पत्नी के तरह साथ में रहना है, बट इवन आफ्टर गेटिंग द ऑर्डर ऑफ द कोर्ट द पार्टीज स्टार्टेड लिविंग सेपरेटली, इवन आफ्टर गेटिंग द ऑर्डर ऑफ द स्टेइंग टुगेदर, restitution of the conjugal rights to conjugate together to restore their rights, even if the court tried, still they are unable to stay with each other, still there is no peace, no mental peace when they are staying with each other, right? So here the court says that yes, you can take the divorce from each other because you are not fit for each other, You are not confirming each other, you are not tolerating each other, so there is no point of this marriage and you can terminate this marriage easily. So this can be a strong ground for the termination of the marriage. Okay. Next, under the clause 2, we have understood that when there is the husband or wife, okay, this is specially for the wife, जब एक वाइफ को ये पता चलता है कि उसका होते हुए उसका पति कहाँ पे भी दूसरी शादी कर रहा है, then in that condition it is sure that the wife can sue for the ground of the divorce. Yes, that means when in the case of marriage solemnization before the commencement of this act, that the husband had marriage again, and before such commencement of any other wife or of the husband married before such commencement was alive at the time of celebration of marriage petitioner. Okay, so what does it mean? It means at the time of solemnization of the second marriage, the first wife or the first spouse is totally and completely alive, and upon that ground, the wife can ask from divorce, ask for the divorce from the husband. अगर पत्नी को इस बात का पता चलता है कि उसका रहते हुए उसका पति ने दूसरी शादी किया है, there is the another solemnization of the marriage during the living period of the wife. In that condition, that kind of the agreement or that kind of the contract or in that kind of the conditions between the marriage becomes void. And here it is clearly said that the court can grant a decree of the divorce upon this specific ground. Okay. And next, provided that the husband has, since the solemnization of the marriage, has been guilty of rape, sodomy, or bestiality. Okay. So, if you would have understood this, then there is some other grounds of the marriage also under the clause 2. So, what does it mean? The first point it was the since the husband has the solemnization of the marriage, शादी के होने के बाद the husband has been guilty of, husband किस चीज का guilty है? Rape, sodomy or bestiality. For example, your husband has committed an offense and that is the offense of the rape. Okay, अपने पति ने किसी को रेप किया है, किसी के साथ सोडोमी किया है. सोडोमी मतलब seducing someone or physically abusing someone. Bestiality मतलब having forcefully physical relations with the animals, that is called the bestiality. So when it has been seen that the husband is accused of rape, sodomy or bestiality, वहां पे भी that can be a strong ground for the wife to get relief from this kind of the marriage, because it has been believed that the person who is doing the act of the rape, sodomy, or, or, or the activity of the bestiality, that means that person is not mentally stable. That person must have something wrong, something bad in mind, and that is leading that person to do this kind of the activity. You may ask me that, ma'am, what is bestiality? Bestiality means forcefully keeping physical relation with the other uh, animal. Okay. Bestiality is basically a psychological disorder जिसको बोला जाता है कि the person who is highly sexually active or highly sexually addict, कभी कभी they do this activity of the bestiality. Sometimes they do have the sexual intercourse with the pet dog or some kind of the odd things that also comes to the news day by day. It can be seen that sometimes people is having their physical intercourse with the animals, and that is called the वेरी वेरी बैड थिंग एंड इसको बहुत घिनौना चीज बोलते हैं. दैट इज कॉल्ड द एक्टिविटी ऑफ द बेस्टालिटी. सो इफ योर हस्बैंड हैज बीन punished for the activity of the bestiality or rape or sodomy, then in that case, this marriage can be considered as void in nature, and with these crimes, you can reject your husband and you have the chances to remarry. Okay. Second condition we have understood that in a suit under section 18 of the Hindu Adoption Act, in a proceeding under section 125 of the CRPC, or under the corresponding section 488 of the uh, Code of the Criminal Procedure, a decree or order, as the case may be, has been passed against the husband, awarding maintenance to the wife, notwithstanding that she was living apart, and since the passing of such decree or order, notwithstanding between the parties has not been resumed for 1 year or upwards. Okay, so what does it mean? That means under section 125 of the CRPC, it speaks about the mental cruelty, the physical cruelty, and other things it has already talked about. And we have also studied about the Hindu Adoption and Maintenance Act. So it has been told that according to the Hindu section 125 of the CRPC speaks about the maintenance, which speaks that even if there is a Muslim woman who has been married under the Special Marriage Act, is allowed to get their uh, maintenance according to the law. Okay. So maintenance is a very important thing which need to be paid to each wife for the maintenance of their themselves and for the maintenance of their child. Okay. So when we're talking about the maintenance, then we can understand that under the Code of the Criminal Procedure and under the Hindu Adoption and Maintenance Act, it has been told that a husband is bound to maintain the wife. तो यहाँ पे हमने जो जो सारे कंडीशंस डिस्कस किए ना, उस कंडीशन के हिसाब से अगर एक बीवी को अपने पति से तलाक मिलता है और डिवोर्स मिलता है, इन दैट कंडीशन द वाइफ हैज द कैपेबिलिटी टू क्लेम फॉर द मेंटेनेंस फ्रॉम द हस्बैंड, and the husband has the responsibility to maintain the wife and the children itself. Okay. But the third condition it has also speaks that her marriage was solemnized before she attained the age of 15 years, and she has repudiated the marriage after being the age of 18 years. अगर किसी का शादी 15 साल से पहले ही हो गया है एंड आफ्टर द अटेनिंग ऑफ द 18 years उसको इस चीज का समझ है कि उसके साथ जो भी हुआ था वो गलत हुआ था, and she was not supposed to be married before the age of 18 years. And in this case, if the girl wants divorce from her husband, then the court can grant the divorce to that particular person. Okay. So यहाँ पे अंडर सेक्शन 13 हमने बहुत सारी चीजें डिस्कस किए. क्लॉज 1 के अंदर हमने बहुत सारे कंडीशंस डिस्कस किए, जैसे कि आपका एक्स्ट्रा मैरिटल अफेयर्स हो गया, आपका जुडिशियल सेपरेशन का कंडीशन भी हम लोगों ने पढ़े, एंड हम लोगों ने ये भी पढ़े कि अगर किसी को आप क्रुएल्टी से ट्रीट करते हो, किसी के साथ 2 साल से साथ में नहीं रहे हो, किसी को छोड़ के चले जाते हो, आपका दिमागी हालत ठीक नहीं है, या फिर आप कोई रिलीजन बदल देते हो, देन उस कंडीशन पे आपका डिवोर्स ग्रांट करना आसान हो जाता है, एंड इन दैट कंडीशन यू आर अवेलेबल और अलाउड टू बी ग्रांटेड द डिवोर्स. सेकेंड कंडीशन हमने पढ़ा कि जहां पे पार्टीज को जुडिशियल सेपरेशन और रेस्टिट्यूशन ऑफ द कंजुगल राइट्स ग्रांट हो चुका है, जुडिशियल सेपरेशन ग्रांट हो चुका है, तभी भी जुडिशियल सेपरेशन के बाद 1 साल से एक दूसरे के साथ नहीं रह रहे हैं, इन दैट कंडीशन दे कैन बी ग्रांटेड डिवोर्स. If they has been granted the restitution of the conjugal rights, जहाँ पे उन पार्टी ने एक दूसरे से अलग ना रह के साथ में रहने के लिए कोर्ट ने ऑर्डर किया है, बट इवन आफ्टर गेटिंग द ऑर्डर ऑफ द कोर्ट बोथ ऑफ द पार्टीज आर स्टेइंग सेपरेटली, in that condition also the divorce can be granted. The next condition जहाँ पे husband is being like husband has been getting married again, वाइफ को पता चल रहा है कि उसका होते हुए उसका पति दूसरी शादी कर रहा है, in that condition also the first wife is granted divorce if she wish to. एंड द नेक्स्ट एंड मोस्ट इम्पोर्टेंट कंडीशन, जहां पे हस्बैंड के ऊपर रेप का चार्जेस से गिल्टी ऑफ रेप, सोडोमी और बेस्टालिटी, ऐसा कोई घिनौना एक्ट, घिनौना एक्टिविटी का जो भी है चार्ज किसके ऊपर, पति के ऊपर है. द एक्ट ऑफ द रेप, द एक्ट ऑफ द बेस्टालिटी, बेस्टालिटी मीन्स हैविंग द सेक्सुअल इंटरकोर्स विथ ए एनिमल. द सोडोमी, किसी को सेड्यूस करना, फिजिकली टॉर्चर करना, फिजिकली सेड्यूस करना, that is called the act of the sodomy. So if this kind of the activity has been done by the husband, then the wife can ask for the divorce upon that ground. And divorce ग्रांट होने के बाद और डिवोर्स ग्रांट होने से पहले जब तक डिवोर्स का केस चलता रहता है, उसी के बीच में वाइफ एंड चिल्ड्रेन को मेंटेनेंस देना पति का कर्तव्य है. दिस हैज बीन डिक्लेयर्ड बाय द कोर्ट दैट द हस्बैंड इज बाउंड टू पे द वाइफ एंड द चिल्ड्रेन ड्यूरिंग दैट स्पेसिफाइड टाइम पीरियड. एंड लास्टली, अगर बीवी का उम्र 15 साल से पहले उसका शादी हो गया हो एंड 18 साल तक पहुंचते पहुंचते उसी को ये चीज का रियलाइजेशन हो चुका है एंड दैट द वाइफ डोंट वांट टू स्टे विद द हस्बैंड एनीमोर, उसको तलाक चाहिए, वो पति के साथ रहना नहीं चाहती है, उसके साथ 15 साल की उम्र में जो शादी करवा दी गई थी वो इलीगल था एंड दैट वाज नॉट फाइन. सो इन दैट केस ऑल्सो द कोर्ट कैन ग्रांट द डिवोर्स टू द वाइफ. So these are the conditions for the granting of the divorce under section 13 of the Hindu Marriage Act. So from the next section onwards, we are going to continue in the next class. This is all for today. Thank you. If you have any kind of doubt, you can ask me in the next class. Thank you.